My task is to introduce you to these very fast proceedings, in particular the first instance proceedings on the merits. It is so fast that we call it a race against the time. Indeed, the goal of Europe is allow the plaintiff to obtain the first instance sentences in 1 year only. Later, I will focus on the compensations for damages procedure. Europe give the winning party the chance to obtain substantial compensation of damages in addition to the recovery of cost. With regard to the cost, the last part of my presentation, we have heard multiple times that it is an expensive procedure compared to a standard lawsuit in Italy. I will see if this is true and which element must be taken into consideration in order to make this comparison. The UPC procedure, is it really a race against the time? Yes, yes it is, if compared to Italian proceedings. The question is, how does it work? The first thing is looking into the preamble of Europe, where we find the list of the principles that regulate the proceedings and his objectives. Based on preamble number 7, the proceedings will be conducted in line with the principle of proportionality, flexibility, fairness, and equity. And in accordance with this principle, with a certain flexibility, the duration of the process will be only 1 year. In damages, we have to be decided at the same time or as soon as possible, as we will see later. And the parties will be required to cooperate with the court and file all supporting documents immediately. We have to be ready to face such a complex procedure in a short time with a team of lawyer consultants ready to be active on the case from the day 1. Let's go into details. Let's go into the stage of these proceedings. These proceedings is made of 3 phases: a written phase, an interim phase, which may include an interim conference with the parties, and an oral phase, which should include an oral hearings of the parties. Within 1 year, the court should issue the decision upholding or dismissing the plaintiff claim on the merit of the case. This decision may or may not include the damages award, depending again on the claim formulated by the claimant. The plaintiff, the claimant, has the option to postpone the damages claim to a later stage, starting a second different proceeding totally dedicated to the investigation on damages. The procedure for the award of damages will be focused on providing the judge with evidence about damages possibly suffered by the winning party. During this procedure, the plaintiff can ask to lay open books. This possibility has been very positive and useful, in particular by colleagues coming from jurisdiction where this discovery tool is not available. On the contrary, Italian lawyers are familiar with this kind of discovery tool. The last step is represented by the procedure for the cost, which is a short procedure that allows the winning party to submit to the court all costs in order to enforce its right. Below in the slide, you can also see an approximate timeline of the proceedings. As you can appreciate, even if we sum the time needed for the proceeding on the merit to the time needed for the proceeding for damages, compensation, we end up with a total time that is in any case shorter than a standard Italian proceeding on the merits. Focusing on the written phase, As you can see from the slide, the first 6 to 9 months of an infringement case are very intensive. Deadlines would be the same also in a revocation case. The first step is to file the statement of claim or the statement for revocation of a patent. It must contain all the facts, evidence, argument, and proposition of law relied upon. Within 1 month of the service, the defendant may file the preliminary objection on the ground of lack of jurisdiction, lack of competence, wrong language. This preliminary objection will be decided by the judge rapporteur as soon as practicable, having heard the parties. That means that the objection will be immediately clear before going ahead with the case. Within 3 months from the service of the statement of claim, the defendant has to file the statement of defense and a possible counterclaim for revocation, with again all the available evidence and arguments. After this, there will be the opportunity for subsequent rounds of written pleading by both parties. During the written phase, based on the defense and counterclaims of the defendants, the plaintiff may decide to file an application to amend the patent. Contrary to what happens in Italy, this amendment application can be filed only 1 time unless the court authorizes future amendment. The claimant must notify the proposed amendment to any other court or authority seized with other proceedings concerning the same patent. Always, during this written phase, there will be, for the parties, the possibility to request for the appointment of a technical qualified judge. We have already heard from Alessandro the advantage of the meaning of having a technical qualified judge appointed by the court. Once the written phase is over, the judge rapporteur notifies the party of the end of this phase, and we start the interim phase. This stage is under the control of the judge rapporteur. The interim procedure should be completed within 3 months of the end of the written procedure. During this stage, the judge rapporteur will focus on the preparation of the oral phase, and this may mean asking the party to attend an interim conference aimed at asking and provide the clarification on certain points, going through a certain levels of evidence, integration, and possibly consider the option to make tests or experiments. Once the interim phase is completed, the proceedings will move on to the oral phase. And this oral phase is under the control of the presiding judge. The judge rapporteur will summon the party to an oral hearing within 2 months after the interim phase is closed. The oral hearing should be 1 day long, but it could be longer only in appropriate case. During the oral hearings, the party will be required to go through their arguments, and expert or witness will be heard if needed. According to the ROP, the written final judgment should be issued by the judge or the panel of judges within 6 weeks of the hearings. As said earlier, the claim for damages can be formalized within the statement of claim of the proceedings on the merits, or with a separate claim for damages that introduces the new independent proceedings. Let's see the difference and how it works. There are 2 options. The rules of procedures provide 2 ways for the determination of damages, or directly in the context of the infringement proceedings, whereby the amount of the damages is immediately stated by the court in order with the decision of the merit. I call this short tour. Or in a separate damages proceedings following the proceedings of the merit. In this second case, we can have a medium tour where the decision on the damages is taken on the basis of a party arguments only, or a long tour after having ordered the infringer to open its book to the claimant. However, because arguments on calculation damages complicate proceedings, and since the law provides room for discretion, we would expect that only in exceptional circumstances damages will be directly claimed in the judgment on infringement in the short tour. It would be, for me, much more likely that separate proceedings will be started after the proceedings on the merits. The medium tour is, in this case, the winning party cannot wait too long for starting the proceedings on damages. The deadline for the filing of the application for the determination of damages is 1 year after the final decision on the merit is issued on both infringement and validity. Such an application for damages, if contested by the losing party in the merits, will start as 3-stage proceedings similar to the one used in the first instance proceedings, written phase, interim phase, and oral phases. But the judge rapporteur may set an abbreviated timetable. The long tour, this is the slide of the long tour. What is the differences from the medium tour? In this case, the application of the determination of damages also contains the request to lay open books. The defendant may either accept voluntarily the request or lodge defense. In the second case, there will be an exchange of deed among the parties, after which the court will decide of the request. In the positive case, after the examination of the book, the court rules on damages request. It is actually light that the books of the defendants will be the preferable source for assessing damages, as they give the size of the infringement activities and its impact on the claimant business. Such a measure has been commented as an effective and useful tool to make the request for damages. Italian IP colleagues already know the potential effectiveness of these measures. We already have something very similar, the disclosure of accounting documentation in our proceeding. Shifting to the substantive law, we find in Article 60A of the UPCA the legal basis for the award and quantification damages. Criteria are those indicating also in the Enforcement Directive and implemented in our Industrial Property Code, with some differences. As far as quantification criteria, the plaintiff should be awarded with damages appropriate to the harm actually suffered as a result of the infringement. The patentee shall not benefit from the infringement, and damages, this part is not present in the enforcement directives, the damages cannot be punitive. The intention is to put the injured party in the same position it would have been if no infringement had taken place. Compared to the Italian system, we may see a difference, for example, in the respect of the psychological elements. According to Article 60A(1) of the UPCA, an infringer who knowingly or with reasonable ground to know engage in patent infringing activity shall pay appropriate damages. But in the event that the court finds that the infringer did not knowingly or with reasonable ground to know engaged in the infringement activity, the award of damages can be limited to a recovery of profits or payments of compensation. It is interesting to know this provision, which provides for a limit, a sort of limit to compensation for damages on the basis of the criteria of knowledge of infringement. It will be interesting to see how this rule will be interpreted by the court. For example, if the publication of a patent would be evaluated as a reasonable ground to know the infringing consequence of the defendant's business. What above can in any case appear limitation to the scope of damages claim if compared to the Italian approach, more inclined to a strict liability. Going back to quantification criteria, Article 68, paragraph 3 states that the UPC must take into account all appropriate aspects, including negative economic consequence, including loss of profits and any unfair profits, and, if appropriate, elements other than economic factors, such as moral prejudice. In appropriate case, the court may use an alternative method of calculation and set the damages as a lump sum on the basis of elements such as the amounts of royalties or fees which would have been due if the infringement had requested authorization to use the patent in question. These criteria are the same, close to the criteria applied in Italy. There are various aspects which make this procedure attractive for the owner of an infringed patent. First of all, with a single case, it is possible to obtain compensation for damages in all the UPC states, potentially 25 countries. There is a single common law for the assessment of damages, with a single procedural law, a single substantive law, and there is a fast proceedings, 1 year or a little bit more. The applicant may request an order to lay open books. This is an accurate and safe option for assessing the size of the infringement of the damages. The court may also order an interim award of damages to a winning party with a sentence of the merits. Due to all these aspects favoring the claimant, proceeding on damages before the UPC may well become the preferred choice when it comes to determining the amount of damages that a winning party may demand for the infringer. The last part of the presentation is about the cost and the procedure for cost decision. First of all, I would like to underline that the fees before UPC are pretty high compared to the Italian system, even if lower than in other European countries. Moreover, the losing party may be responsible for all costs of the winning party. It is a loser pays regime. Article 69 of the UPCA, in fact, provides as a general rule that reasonable and proportionate costs and other expenses of the winning party should be borne by the losing party, unless fairness requires otherwise. For this reason, cost and fees risk should be taken into account at the start of any action. What are these costs? Court fees in the UPC are a mix of fixed and value-based fees. All action before the UPC will attract fixed fee. For example, as you can see, the fixed fee for an infringement action is 11,000 euro. The fixed fee for an application to determine damages is 3,000 euro. In addition, these proceedings will attract also value-based fees, where the value of the proceedings exceed the 500,000 euro. The value-based fees depend on the value of the action, calculated based on the claims of the party. Revocation action and counterclaim for revocation do not attract a value-based fees. Revocation counterclaim will attract the same fees as the infringement action in which it is filed, up to a cap of 2,000 euro, which is also the fixed fee for a revocation action. 20,000 euro, yes. Fees are to be paid in advance based on preliminary indication in the complaint. This is a requirement for the claim to become lodged. Then the fees are determined by the judge rapporteur in the interim procedure. There is also, it's interesting that there is also a fee reduction for around 40% for small and micro entities, as well as further reimbursement where a single judge hears the case or where the case is settled or withdrawn earlier.
Something that is quite interesting and is different from Italian system is that you cannot say I'm not infringing because the patent is invalid. You are forced, you cannot do eccezione di nullità. We are forced to file a counterclaim. So that means basically start another action, and that's why there are more fees.
Yeah.
Yes, it's another.
And in the case management system, that is a completely different action, by the way. So it's not even the same number, and so. And may I say one thing more? You can, of course, also get the costs in the first instance. So you don't have to go through the cost proceedings.
Yes, of course.
So
yeah, the first proceeding.
So if it goes quick, then the damages can't be very high, and you may accept, for instance, a certain amount of damages which are very easy to establish. And so then you can have damages, maybe somewhat more limited than everything else, and cost in the same 40 months, 12 months.
Yes. Okay. Yes. It's interesting to say also that the court fees are recoverable in full. All the costs are recoverable with the only limits of the cost for representation, the lawyer fees, that have a cap based on the value of the case. In the slide, there is a list of all recoverable costs. The winning party shall be entitled to recover all the court fees, reasonable and proportionate cost for representation, witnesses' expenses, and so on, all the costs. Only unreasonable and unnecessary costs will be borne by the party which incur them, regardless of the outcome. The fact that the costs are all recoverable is, of course, a very good news. Of course, the condition is one and only: it is to win the case.